So I have an important update in the current battles against the state of Illinois and their ban on so-called assault weapons. As I mentioned in the intro, in this video, I have some news on the current battles which are attempting to strike down the Illinois ban on so-called assault weapons and their magazine bans. These current actions could also have huge implications not just for the state of Illinois, but other states as well. These cases are asking for the Supreme Court to intervene on an emergency basis to halt the rifle and magazine ban once and for all. However, at the same time, a lower court judge is moving the cases towards a final decision in the hopes that at the very least, a merits decision will fast track the review of the higher courts if the Supreme Court denies emergency review in these cases. Now, you may recall that recently we received news that the Supreme Court denied 2 emergency injunction requests, which were asking for the United States Supreme Court to step in early and put a temporary halt on the Illinois statewide ban on rifle and magazines. Those cases were the Culkins v. Those cases involved a challenge to the Protect Illinois Communities Act, also known as PICA, which places unconstitutional restrictions on rifles and magazines within the state of Illinois. PICA also requires a registration requirement to grandfather in already possessed rifles. In Culkins, after a state Supreme Court decision, the plaintiffs filed for a writ assert to the United States Supreme Court. In the Culkins case, the plaintiffs also filed an additional emergency stay request, pending Supreme Court review, and that went to Justice Barrett. However, the Supreme Court denied both the request for the emergency stay and then later denied taking review of the entire case after they held conference on January 5th.